Good morning and welcome to Immigration Friday. I am Rumbi Vunzawabaya from Tulia Group, Community Interest Company. We're a community interest company based in Coventry in the United Kingdom. And every Friday, we do an Immigration Friday where I talk about some of the questions that people have asked us or some of the key developments in immigration law in the United Kingdom. Today, I'm answering a question that we've had in so many different formats from different groups of people. And that question revolves around bringing children to live in the United Kingdom with their parents. So we have parents who are living in the United Kingdom for various different reasons. And some of them are coming here as spouses of people who are settled here as settled workers. Others are coming here as dependents of skilled workers. So parents may be working in all different sectors, in medicine, nurses, carers, civil engineers, IT, people who are working in IT, in all different sectors. And families need to be united together and to live together. But it's not always a whole family that comes. Families come in so many different shapes and sizes and different types of families. So you have blended families with children who may have different children in one family with different sets of parents. So we have all different types of groups and types of family makeup. The world that we live in is becoming a global village. And so we will have children who are living in Zimbabwe, parents living in the United Kingdom, children living in South Africa, parents living in America, all different types. There are some people who came to the United Kingdom many years ago and did not come with their children and have struggled to settle and to get their indefinite leave to remain and British citizenship, and are only bringing the children to join them after a long separation. So there are many different dynamics. But one of the things that is common to all families is the concept of sole responsibility. Sole responsibility. And this concept is found in what's called Appendix FM and Part 8 of the immigration rules. And so today, what I'm going to do is respond to some of the questions that we've had and just give an analysis of the circumstances of a child's upbringing and how that is applied to immigration law and to the various applications that can be made. Right. So when is sole responsibility required? When is it required? You must demonstrate that you have sole responsibility where you want to bring a non-British child to the UK to live with you. So this applies to a non-British child to live with you. And you as a parent are applying for or already have limited leave as a parent under Appendix FM, or you've been granted limited leave to re-enter or remain under another route, such as a skilled worker route, or you are present and settled in the UK. So those are the three types of leave to remain. So you as a parent either are settled already in the UK, either you've been granted limited leave to remain in another category, or you are applying or already have limited leave to remain as a partner or as a spouse under Appendix FM. So where sole responsibility comes into play is where perhaps you have met with someone and you already have children from a previous relationship. You're now coming to join your spouse in the UK and you've got your own children and you're coming to join a spouse. You have to meet the requirement for sole responsibility. Or you've been granted leave to remain, you're a single mom, dad is remaining in another country, and you are coming to the UK as a skilled worker. Or you as a parent are present and settled in the UK, the children are in another country, and they're now coming to join you. So non-British children coming to join. Right, next. And so if you want to join, if you want to join a child who's in the UK and is a British citizen, or has settled in the UK for at least 7 years, and you would not be eligible under the Appendix FM partner route, you may also have to rely on sole responsibility. So that's another category, but we won't go into that a lot today. So there's a term called the burden of proof. The burden of proof. He who asserts must prove. So you who's making the application has to prove that you have sole responsibility for the child that you are applying for. This is unlikely to be an issue where both parents will be living together in the UK or where only one parent is alive. So where both parents are coming to the UK together, this will not be an issue. And where only one parent is alive, again, it won't be an issue. However, in parenting arrangements where parents may have divorced or parents choose to live in different countries for work reasons, demonstrating sole responsibility for the purposes of immigration rules is often very difficult, even if both of the parents support the child's move. So supporting the child's move is not enough. Yeah, it's not enough. It's not enough. So now I'm going to go on to how is sole responsibility defined? How is sole responsibility defined? So sole responsibility is not necessarily the same as who may have legal custody or access to a child. Under the immigration rules, it is a factual matter that's to be assessed, taking all the evidence into account. So it's not the same as legal custody. It's not the same as having legal guardianship, and it's not the same as having access to a child. There is a case that is called TD Yemen. So I have read this case many times and referred to it. So TD Yemen, which is the leading case on which factors should be considered for sole responsibility. And the court acknowledges in this case called TD Yemen that other adults, including relatives, may also have sole responsibility towards the child's daily care, such as getting them to school or even living with them. However, sole responsibility only arises where a person has exclusivity over the continuing control and direction in respect of the important decisions about a child's upbringing. Right. That's interesting, isn't it? I think it's really important to understand what type of issues are referred to. And the Home Office guidance gives examples of such decisions. So there is a lot of guidance. And what you'll find is when you look on the form, it doesn't ask you to prove sole responsibility. The form looks pretty simple. But what it is when decisions are made by the entry clearance officer, they want you to prove sole responsibility. So some of the questions that we have is, I've received this letter from the Home Office and I don't know what to do. How do I prove this issue called sole responsibility? How do I show this? So that's why it's important to look at the guidance and to get legal advice, because I'm giving this information for free. And it's something that we do as an organization. We give free guidance and free information, but every single case is unique. And that's why it's important for you to get advice regarding your situation before going through the whole application by yourself. So the Home Office guidance provides examples of such decisions, and this includes their education. Remember, exclusive decisions over decisions. Yeah, the continuing control and direction, important decisions about a child's upbringing, education, their faith that they're raised in, whether they undergo certain medical procedures, what recreational activities they take part in, what to do with the child's property. And there's no minimum period for which sole responsibility must have been held, but the Home Office guidance does say that only recent change of arrangements should be scrutinized to make sure that this is genuine and not an attempt to circumvent immigration control. So they want to see a pattern and a history of sole responsibility. They want to see that you haven't just done it now when your child is 17, turning 18, and you think it would be good for them to come to the UK for university and further education. They want to know that you've had sole responsibility for that child since they were a child. They want to understand why you haven't made an application just months before their 18th birthday. They want to understand all these things because it is important to show that you're not just trying to circumvent immigration control. The fact that a child may not live with or be geographically close to a parent does not exclude that parent from having parental responsibility. So technology makes it easier to consult and decide on a child's future and to have an active connection with the child. Even letters from school, WhatsApp groups for parents, emails from the school, correspondence, evidence to show all the things that you've been doing and how you've been doing it. So your evidence is important. It's not just enough to say, I have done this. It's not enough to just say, I have sole responsibility, but you do have to demonstrate how you have sole responsibility. Does supporting the child financially count? So the Home Office guidance states that financial contributions to the child's upbringing are a factor to be considered, but are not sufficient in themselves to show sole parental responsibility. This is true even where the contributions are significant, such as school fees or housing or anything. Yeah, so it's not just the financial element. It's a factor, but it's not the sole factor. So what is the starting point? Where do we start in determining who has sole responsibility? So where a child's parents are both involved in their life, the starting point is that both parents share responsibility for their child's upbringing. That is the starting point. That mother and father both share the responsibility. And that's the suggested approach to deciding sole responsibility in the case of TD Yemen is clear that irrespective of their physical locations, if both parents are involved in the upbringing of the child, it will be exceptional that one of them will have sole responsibility. So if one parent is not in their child's life at all, the starting point is that only the remaining parent has sole responsibility. So if a parent is absent for whatever reason, if a child lives in Zimbabwe, the father went to South Africa to look for greener pastures, and you haven't been able to get in touch with him, you don't know where he is, you can't find him, he hasn't been present, he's disappeared, then we move on to show that the mother is the one who's had sole responsibility if the mother's been looking after the child. Sometimes people will have a child with someone, but they don't take responsibility for the child. They may just come to put their name on the birth certificate, but that stops. That's where it ends, and they're not involved in any way. So where a parent is not in a child's life, the starting point is that the only remaining parent has sole responsibility. You still do need to prove this and show that. And this, again, can be shown through your interaction with school, interaction with the doctors, interaction with church. It can be proved that you are the only parent. The assessment is a factual one of who practically makes the important decisions, which may include another relative or like grandparents may be involved, and especially for people who came to the diaspora many years ago and left children in the care of parents. Then it's now not the other parent who is who has sole responsibility, but it's a grandparent, an uncle, an aunt, whoever has had the day-to-day care of a child and made decisions about them. So it doesn't have to be a biological parent. What if you cannot meet the definition? You may still be able to bring your child to the UK if you can demonstrate that there are serious and compelling family or other considerations which make exclusion of the child undesirable and suitable arrangements have been made for the child's care. It's a very high threshold to meet. There is another case called Mundeba, which talks about this. And at paragraph 37, it provides that the assessment must focus on the specific circumstances of the child in light of his or her age, social background, and developmental history. So the case sets out examples of what may be serious and compelling, such as where there's a history of neglect or abuse or unmet needs that should be catered for. So I'll give some examples of some of the cases that I have dealt with where there's been abuse, sexual abuse of children, where there has been neglect. Children have not been getting basic food, going to school. The parent has not been involved. Alcoholic parents or parents who are addicted to drugs, living with the child and not looking after the child. There's cases where children have become carers of sick relatives, living with grandmother, and grandmother is now very ill, but the child becomes the carer for their grandmother. And those are exceptional circumstances which make the exclusion of the child undesirable. So serious and compelling family or other considerations are important. And again, you can show evidence. So for example, your child has been living with their dad, but they live with a stepmother who is very abusive. Or the children have been living with their mother. The mother gets married and the children get abused sexually by their stepfather. So all of those are examples of some of the issues where it becomes serious and compelling family or other considerations which make it undesirable for the child to be excluded from the United Kingdom. Simply wanting the child to be in the UK with you will be insufficient. It's not enough. Simply just wanting a child to be here is not enough. They're my child, they should be here. Those are some of the arguments that we've heard, and that is not enough. So it's important to understand what the law requires and then to put the evidence that supports what you are saying with your initial application. So treat your initial application with the seriousness it deserves, send the evidence that you need, get advice if you need to, make sure that you have evidence to support your individual case. So we may have people who are coming on skilled worker visas, some are coming as carers, other people don't want to come and live in the UK and be carers. And now there's a tug of war over the children. So those are particularly complex cases. And again, if you are in such a situation, my advice is get advice specific to your situation before you make an application. Because when you ask for advice from anybody everywhere, they will tell you what they did and they'll say, do this, it worked for me. I've seen people being sent copies of applications that we have done, like a template, and being given to somebody else. And that person has copied what has been written by somebody else. And even to copy the gender of the child, when you're applying for a girl and we've made an application for a boy, you copy the gender. So it's important, again, in those circumstances, to be able to know your situation and what evidence you need and what your situation is from the beginning. So if you're able to get the advice and evidence from the start, you have a much better chance of succeeding. So I hope that has been useful, and that is just a whistle-stop tour through the law, through the type of evidence that we need for sole responsibility when you are bringing children. If you need further advice, please do not hesitate to contact Tulia at info@tulia.org.uk, visit our website, which is www.tulia.org.uk. We can take up to 7 days to respond because we do have a lot of inquiries coming through, and we prioritize some of the work that we are doing locally as well as in our city. So we get some referrals which are fairly urgent, where we're dealing with certain matters there. So you can also WhatsApp for an appointment on the number that's on the screen, or you can visit us via our website, as I've said before. It's extremely important to be able to just get as much information as you can from there. We are on our website is www.tulia.org.uk. Please visit our website to see upcoming events. We do have a webinar coming up on Tuesday next week, just after Easter, and my husband and I will be talking about a book that we have written. We have such a passion about healthy marriages, and it's called Threefold Cord. Threefold Cord, twisting my words. So one of the areas that we work in Tulia is giving family law advice, people who are getting divorced, domestic violence, and together we've had so many years of marriage, 25 next year, and we've also volunteered for organizations that support marriages. We've run what's called a Together group, and we're passionate about healthy marriages and healthy relationships, and encouraging people to have these healthy marriages. And so we're coming up with a webinar which is called How to Divorce Proof Your Marriage. I don't think we've got a secret formula, but we're going to share some of the tips that we've learned, and also some of the extracts from our upcoming book, so that we may be able to help one or two people. So if you're interested in that, please register on our Eventbrite for the upcoming event, and visit our website at www.tulia.org.uk, where you have all the information of our upcoming events. We also run a recovery from divorce and separation course, which is made for immigrants and migrants living in the UK and migrant communities. And we have a face-to-face event, which is on the 24th of April, 2022. Where we've had groups running right through the pandemic, and some of the people, so during the lockdown, we've been running most of our events online, and this is a face-to-face event where people will be able to meet for the first time. So if you're interested in just hearing about this recovery program that we're doing, some of the experience of the people that we've had, please do come and join in. The details for the event are on our Facebook page or our Instagram page. You can text me or text any one of our team, who will get back to you and give you more information about the work that we're doing and the upcoming events. We offer every Tuesday 15-minute free consultations, and you can book one on the link that is on the screen, and I believe the link is also going to be in the chat. So you can book a 15-minute consultation if you just got a quick question or there's information that you need. We are here to serve, and we're able to provide quick advice, but we also offer paid consultations for a longer period of time, which you can find the link on our website. And please, when you visit our website, sign up for our newsletter so you can get access to all the upcoming news and events relating to migrants, refugees, and asylum seekers living in the UK, or indeed those who are wanting to come to the UK to live here. Thank you so much for watching. Have a wonderful Easter. May you be blessed today. And today is Good Friday, and may you be blessed this weekend. May you find time of rest. May you find time to reflect on the finished work of the cross. The work that we do at Tulia is inspired by our Christian values as an organization, and Matthew 25 is one of the anchor scriptures that we rely on, and we look out for those who are displaced, for those who are destitute and homeless, for those who are hungry, for those who are in chains of bondage, even from not having their immigration status and being found to be in a position where they're unable to settle unable to access resources, unable to access services, unable to work. And we know that the work that we do brings about a liberty to people and takes them from a place where they are unable to take part in society to the full capacity that they can. And we help them through our knowledge of the law, through our restorative programs, through our prayer ministry, through our listening service. We are there to serve our community in the way that we know best, using the skills that we have as a group and a corporate body. So we wish you the very best this Easter. And yeah, see you next Friday when we have our next topic. If you do have any questions, please do not hesitate to let us know so that we can address your needs on our Immigration Fridays. Have a happy Easter and be blessed.